Hi, I'm Richard Parsons, a solicitor working in the UK in a firm in London. So, for our purposes, the 1954 Act is the legislation that sets out the relationship between landlords and tenants of commercial property at the end of the lease. In other words, it's the laws which decide, can the tenant stay on and get a new lease, or does the tenant have to leave? It can be excluded, but there's a very strict procedure that has to be followed for the exclusion to be valid. So simply writing in the lease that the 1954 Act won't apply isn't enough. The procedure involves serving a particular notice on the tenant, which explains what the Act is, explains the rights that he would have had, but he's not going to have because the protections have been taken out. And even more than that, the tenant then has to go and see a solicitor, sign a piece of paper to formally declare that he's happy to lose those rights that he would have otherwise had if the 1954 Act had applied. It happens mainly in relation, I'll give two examples where it's common. One example is where the lease is very short. So if somebody was going into commercial premises for say a year or 2 years, it may be in the interests of the landlord to exclude the 54 Act. The second example I would give is where the landlord perhaps knew that he wanted the property back at some future time. So he may have plans in mind down the road, and he would very much prefer to ensure that when the lease comes to the end, that's final, the tenant's going to leave. Well,
it sounds to me as if it's not, because the protections are all on my side. Yes, the protections are your side.
I suppose that there's two situations when you ought to be thinking about it. The first is when you're at the beginning of the lease and you're negotiating what's going to be in the lease, and of course the question is whether or not the landlord's going to ask for it to be excluded or not, and if he does ask for it to be excluded, whether that's going to be acceptable to you. The other situation is at the end of the lease, when perhaps the landlord's asked you to leave, or he's asked you to accept new terms for the lease. Maybe he wants the rent to be higher, for example. And if you're not familiar with the 1954 Act, if you don't speak to a solicitor and get legal advice, then what's going to happen is you're not going to be aware of the rights that you would have otherwise had if you were simply aware of them. Absolutely, they're rights that protect the tenant, the commercial tenant, and very recently indeed, only in the past few weeks, I was in a shop. I was acting for the tenant, I was looking at his lease. It was obvious that the lease that they had used was old, and it tried to take away rights which the tenant would have otherwise had under the 1954 Act. It hadn't been drafted properly. If the tenant didn't know any better, he would read the lease and assume that that was the position in law, but in actual fact he had a lot more rights that he didn't know about. In my experience, I haven't seen any deals fall through on that particular point. Normally the rights of the tenant and the landlord will coincide one way or the other. So if it's the sort of business where the location is very important, where the length of the lease is very important, for example, if the tenant is going to set up a shop and over a period of time they want to increase their reputation, more and more people will come back and visit that same location, then it's naturally going to lead to a longer lease, it's naturally going to lead to the tenant wanting more security. If the landlord is willing to grant that longer lease, 5 years, 10 years, 15 years, whatever it is, it's also likely that he's going to be willing to allow you to have the 1954 Act rights. If you're the sort of business which is perhaps a new business, the location isn't so important, perhaps if you expand you're going to want to move, you're happy with a lease that's only 1 or 2 years, well, in those circumstances, quite often the landlords simply don't want the headache of having to deal with the 1954 Act. They'd rather the lease was just a simple 12 months, simple 24 months, whatever it is, so that at the end of the lease, it ends, there's no complications. Well, naturally, I would advise you to take legal advice if you're looking at signing a commercial lease. When you're a business, the courts are not very forgiving at all of businesses who decide to be their own lawyers. But specifically on this point of the 1954 Act, it's not the small print that governs it. Even if the small print in the lease said you don't have the rights of the 1954 Act, unless they've been through that formal procedure of serving you notice, you going to a solicitor and signing that you understand those rights and you're happy for them to be excluded, the small print's going to have no effect. It's not going to matter. Yeah, otherwise you've got the potential of coming to the end of the lease, being totally ignorant of these rights, and then simply leaving the property against your own wishes because the landlord asks you, because you don't know any better. Yes, so just because a tenant has rights under the 1954 Act doesn't mean that the landlord can never get rid of them and that the tenant can stay on forever and ever. So there are certain limited circumstances in which a landlord can still ask a tenant to leave at the end of the lease. Basically, they split down into 2 categories. The first category is where the tenant has done something wrong. So if there's a history of the tenant failing to pay his rent on time, or breaching the covenants, causing problems under the lease, then they're reasons that the landlord could use to refuse to grant a new lease. The second category of reasons why a landlord could still end a lease would be if he had plans relating to the property in the future. So there's a number of exceptions. If he wanted to engage in some sort of property development, for example, that was going to affect the building, if he wanted to occupy the building himself with his own business, and other circumstances like that. So if a landlord did have a project and they wanted to know whether or not they could proceed with an eviction, or if they had to offer a new lease, again they would want to speak to a solicitor, outline the project and find out whether or not it would be an exception under the 1954 Act. Yes, so property development is an exception which really has nothing to do with the lease itself. If a landlord wants to conduct extensive property development to the site, then that is a valid reason to ask the tenant to leave. That's correct. No, the age of the building's effectively irrelevant. It does matter how long the lease is. So if the lease is a very, very short lease, by which I mean under 6 months, then the 1954 Act doesn't apply. Yes, so if a tenant has the protections of the 1954 Act, then the landlord is obliged to serve on the tenant a notice which says whether or not he wants the tenant to leave, and if he is going to offer a new lease, what the terms of that lease are going to be. There's then a process whereby the 2 parties have to negotiate by serving notices upon one another, and it's very strict. So that process has deadlines, and if those deadlines are missed, then you might lose the chance to have a new tenancy agreement where otherwise you would have been able to get it. So if you're facing that process, then that's well worth speaking to a solicitor about. The first notice is normally served 6 months before the end of the tenancy agreement. So if you are a tenant yourself, yeah, put in your diary 7 months before the end of the tenancy agreement to raise this issue, speak to a solicitor.
And if the landlords evict without proper procedure, what happens?
If the landlord
evict without proper procedure?
Yes, so in commercial premises, when we're talking about an eviction, normally what we mean is that simply the tenant goes to work one day and finds the locks have been chained, or there's the locks have been changed, or there's chains around the door handles with a big padlock on, and they've been excluded from the property. That's a very, very dangerous situation for a landlord to be in. The tenant should immediately seek legal advice. It's possible to do an emergency application to the court, and the court can order that the locks be changed back. Now, if the landlord hasn't followed the proper procedures, if they've broken the law by evicting the tenant in that way, then that could be very, very costly indeed for the landlord.
Well, thank you very much. Perhaps just to conclude, you could give us your views on whether the 1954 Act worked, whether it's a good bit of legislation in commercial leases.
Yes, in my experience it works quite well. I think there's a reason that these provisions of the 1954 Act have lasted so long, many decades now, in comparison with other pieces of law which have to be replaced pretty quickly. It's very unusual, in my experience, for these matters to have to be decided by the court after a little bit of negotiation. The 1954 Act normally allows tenants and landlords to be able to do a deal that they can both live with. Thank you very much. Goodbye.